good morning, good afternoon, good evening, wherever you are in the world today. Distinguished colleagues, esteemed partners, and dear friends, it is a pleasure and an honor to welcome you all to this gathering of thought leaders, practitioners, and scholars committed to advancing justice and sustainability in our shared climate future. My name is Advocate Railla Puno. I am a coordinator for the Climate Law and Governance Initiative and Associate Fellow for the Center for International Sustainable Development Law. Today's conversation is framed under the title Legal Roundtable on Building Capacity for Climate Governance and NDC Implementation. Together, we will explore how legal innovation, institutional strengthening, and collaborative leadership can accelerate the delivery of nationally determined contributions and support resilient, rights-based climate governance. This session is made possible through the generous leadership and collaboration of a remarkable group of institutions: the Lucy Cavendish College and Hughes Hall at the University of Cambridge, the Climate Law and Governance Initiative, the Net Zero Lawyers Alliance, the Mandela Institute at the University of the Witwatersrand, the Jigme Singye Wangchuk School of Law, the Center for International Sustainable Development, and the United Nations Environment Program. Their shared commitment to advancing climate-responsive legal capacity building is truly inspiring. It is now my great pleasure to introduce our co-chair, Advocate Layla McClaskey. Layla is a PhD candidate and holds a master's degree in regulatory law from FGV Rio Law. She is also a researcher at the Research Collective on Advanced Studies on Energy Transition at FGV and holds a specialization in fiscal law from PUC Rio and a certification in business law from the Institute of Commercial Management in the United Kingdom. In addition, she works as a lawyer and legal manager. Over to you, Layla. Layla, we cannot hear you. Is your microphone connected?
Yeah, it is. Can you hear me now?
Now we can hear you.
Oh, good. Thank you. Hi, guys. I was just saying nice to meet you all. And so after you mentioned me, so I start with the introduction of the themes of the session, right? And the questions to be addressed, right? So colleagues and friends, today's session invites us to reflect on the legal, institutional, and collaborative capacities required to support effective climate governance and implementation of the Paris Agreement. So I'm going to start with questions, right? They're the focus of this meeting. So why is strengthening climate law and policy capacity important in driving Paris Agreement implementation? What are the leading examples and what lessons have been learned? How can academic institutions and professionals scale up efforts, and what are some of the most innovative tools for high ambition NDC implementation? From now on, we are going to have the presentations delivered by Joe Watterson, Carter Ching, lawyer, Nickett Scott, lawyer also, and Georgina Beasley, all lawyers. And so that's how it is. I'm sorry. Is that how it goes, Railla?
Yes, that's the order of the program. Would you like to introduce the speakers? I could also do it.
Yeah, sure. So right now we're rehearsing, right? Or no?
No, it's ongoing.
Railla to introduce the speakers, given that you know who they are, and Layla is really representing FGV Law, our colleagues. Please, thank you very much, Layla, for helping us to start this session, and Railla, over to you to introduce the speakers.
Okay, thank you so much.
Thank you.
So our keynote presentations will be delivered by Joe Watterson, Advocate Carter Cheng, and Advocate Nick Scott, and Advocate Georgina Beasley, as Layla kindly introduced. Joe Watterson and Advocate Carter Cheng are the program and engagement coordinators, respectively, at Democratizing Education for Global Sustainability and Justice Program, or DemEd Global, at Lucy Cavendish College in the University of Cambridge. Advocate Nick Scott is the Senior Advisor at the Hughes Hall Center for Climate Engagement, University of Cambridge. And Advocate Georgina Beasley is the CEO at the Net Zero Lawyers Alliance. Our panelists are Advocate Zenaida Musa Wadiwala, Advocate Hafiz Khan, Professor Carolina Garrido, Professor Dema Lam, Advocate Ayman Shirkawi, and Advocate Andy Rain, who is unable to join us in person, but has submitted the video that we will be playing later on. I will first now turn this over to Jo Watterson and her colleagues for the keynote presentation.
Amazing, thank you so much. So just to check, everybody can see the screen that Jo is sharing, right? Perfect. So hello, I'm Carter Chang, and it's a privilege to contribute to this important roundtable. And as we gather here at the Climate Law and Governance Day, we are reminded of a simple truth. The Paris Agreement will rise or fall on the strength of our institutions and the capacity of our people. And strengthening climate law and policy capacity is the foundation of which every article of the agreement ultimately depends. So our work in the Democratizing Education for Global Sustainability and Justice, DemEd Global, is grounded in this conviction. So if we can go to the next slide. So we often describe climate change as a new crisis, but in reality, the world has had 75 years of warnings, scientific evidence, diplomatic debates, and countless declarations. And yet global responses remain fragmental, inconsistent, and at times contradictory. And it is not because of a lack of will or funding alone. It's also because of the legal creativity, institutional capacity, and political courage chasm that stand between global commitment and national implementation. And to deliver the Paris Agreement, countries must be able to design governance systems capable of coordinating ministries and sectors and respond to complex risk agilely and also with accountability. And this is where capacity becomes destiny. And countries with strong legal and policy ecosystem would be able to move faster, negotiate better, and withstand climate shock more efficiently. But across our work with governments, universities, and legal communities, whether it's in Kenya's carbon markets or multilateral climate negotiations, we see the same systematic gaps. So if we can go to the next slide. So today, most law faculties still do not offer structured courses on sustainable development or climate law. And then for public policy and civil service schools, rarely train officials on Paris Agreement, implementation, and then Bar Association have limited professional development on climate obligations. And also for judicial academies, in only a very handful of countries actually provide training on climate law and also on environmental constitutionalism. And these gaps represent the difference between ambition and action, and between NDC written on paper and one implemented through effective legislation, regulation, enforcement, and of course, public participation. And to close this capacity gap at scale, academic institution must move beyond the traditional boundaries of legal education. And this is why DemEd Global Program anchored into this commitment and delivers through global partnerships focusing on democratizing access to world-class education in sustainable development and climate law. And I'll now pass the floor to Jo, our amazing program coordinator, who will walk you through what the DemEd Global is about. Over to you, Jo.
Thanks so much, Carter. I feel like that's a great setup to talking a little bit about how DemEd Global aims to fill this capacity gap. So if you haven't heard of us before, we're Democratizing Education for Global Sustainability and Justice Program, quite a mouthful, so that's why we shorten it to DemEd Global. We're aiming to, unsurprisingly, democratize education on sustainable development law and policy to strengthen capacity by developing online courses. And I'll talk a little bit about what those courses look like. So the program seeks to widen participation by making these online courses available worldwide to current and future law and policy leaders by convening and supporting global engagement and communities of practice. Oh, my slides are stuck. There we go. So the online courses that I mentioned, over the past year, the program has provided the following 6 courses, and these have been developed over the first 3 years of the program, and another 2 are currently being piloted. So they kind of revolve around sustainable development education, but also human rights education, economic law and sustainable development, looking at what are the sustainable development goals, a bit about the Paris Agreement, the Global Biodiversity Framework, the wealth economy, trade rules, and the UN Convention on the Rights of the Child. So it's a diverse course offering and how these link to sustainable development and the law. So each course offers 8 to 10 hours of total learning time with 5 focused intensive modules of instruction from leading course experts, as well as assessments. It has 2 live classroom engagements on Zoom, so people from all over the world who are taking these courses can meet and network and brainstorm together. They have access to leading materials and several hours of independent self-paced work. And here are a couple of pictures from the videos that are uploaded for our learners to watch in the online courses. So just a little bit of proof of concept, filling this gap. So the program originally aimed to offer 6 online courses to 4,000 learners and receive 1,000 plus learner evaluations. It has significantly exceeded these initial projections. In the spring of 2025, our course run, which was 3 courses, saw 2,791 learners complete the 3 courses offered in this period. This brought the total number of learners completing the 6 courses and submitting rated evaluations to 10,727 since the program's launch. So you can see that we're massively exceeding those initial projections. And this graph here shows how many people have taken our courses and the growth between years 2 and 3. So an average of 35.6% growth in completions in the fall courses of 2024. So that's the SDGs, the Paris Agreement, and the Global Biodiversity Framework courses. And in the spring of this year, our wealth economy course, you can see, had dramatic growth, 35.4%. And trade rules saw 32%, and the UN CRC course saw the most dramatic growth with 85%. So there's a high demand for these courses. So we recently conducted an impact survey with some of our course alumni, showing 67.2% of learners who completed the courses, participated in a law and policy change process in their home countries or elsewhere. 84.2% taught, shared information, advised, supported, or represented others on the course topics. 83.7% pursued further study or research on sustainable development, and 44.8% joined a new organization or took on a new role since receiving their course certificates. And finally, just to show you sort of where in the world our program has reach, we currently have 170 course ambassadors from 119 different countries helping to democratize education on sustainable development law and policy. So they advocate for the courses in their countries, they inspire other learners to take the courses and make those accessible to them. And now I'm going to hand over to Nick Scott, who's going to talk about building climate capacity across all areas of law. Thank you so much, Nick.
Thanks so much, Jo. Yeah, so I'm just going to really quickly sort of speak through a collaborative project between my centre, the Centre for Climate Engagement, we're based at the University of Cambridge, and the Net Zero Lawyers Alliance. So essentially this project is called the Law and Climate Atlas. And basically what we set out to do was to map intersections, as it says, between climate change and all areas of law. So not just these sort of obvious areas you think about, like environmental law and public international law, but really every area of legal practice. We essentially tried to answer two questions. So how is climate change impacting that particular area of law? And also how can that area of law help to address climate change? And you can probably see on your screen just a list of legal fields. This is for the UK section, which is currently our largest section. And you can see it touches on really every area of legal practice. And in all of these specific areas, we found super interesting intersections. So we go to the next slide. And to very briefly sort of give you a flavor of the types of intersections that we looked at. So the first category I've put there is climate change is when climate change just shapes the environment in which the law operates. So that can be the physical environment. Extreme weather risks are impacting things like insurance law, but it can also be the social and political environment. Then we have where existing legal frameworks, which might not explicitly actually mention climate change, are responding in some way to climate change. And a really sort of big sort of topical example is how fiduciary duties, whether that's for held by investors or directors, are actually really linked to climate change because climate change and other sustainability issues are a financial risk. Third category, I suppose, fairly obvious, is just that there are new laws, new legal frameworks emerging from climate change because of the policy response. But lastly, also that lawyers themselves have unique tools to address climate change. And I've put contracting there as sort of one example, but there are all sorts of other climate solutions that require legal input. So we could go to the next slide. And really quickly, just to some of sort of my key takeaways from this project. The first is that, this has been a project, a collaboration between sort of our organization, which is more academically focused, and the Net Zero Lawyers Alliance, which is obviously a community of practitioners. And I think we've definitely found that both academics and practitioners, and sometimes people actually who sort of play both roles, have really valuable inputs into climate law, which can also be quite complementary. The next is that sort of stepping outside of the climate law world can be really important. So we don't actually just want to hear from lawyers who are experts in environmental law or who are passionate about climate change, but trying to bring in those people who are legal experts who haven't thought about this issue is really important, obviously in terms of sort of getting the resources out there, but actually also in terms of getting people to contribute to the resources. Sometimes we want the leading expert in company law, regardless of whether they thought about climate change before, to engage in sort of climate change as a novel legal issue in their field. Also, that this content isn't just actually useful to lawyers. We sort of made the atlas with legal practitioners as the key audience in mind, but we've seen it sort of cited in academic papers, we've seen it cited in parliamentary debates, and even when we're impact sort of tracking, saw it sort of mentioned in sort of social media posts and sort of comment sections for local advocacy groups. So these are the sort of type of impacts which I think you don't usually think about because the law can be a fairly sort of insular profession in some ways. But I mean, just to say that other people are paying attention. And so building climate law capacity is broader than just climate law capacity within lawyers. And lastly, I'm sure sort of everyone here would understand this point, but just the importance, obviously, of multi-jurisdictional collaboration. We just launched the sort of Brazilian version of the Law and Climate Atlas, which would be great if sort of people took a look at. And it's been so great to work with lawyers across jurisdictions. Sometimes it's tricky to sort of coordinate and make sure that something is centralized and efficient, but it's absolutely essential because the law is fundamentally a sort of jurisdictional subject area. We can't sit in one place and try to just disseminate information out of there. So that's been certainly, as I said, as we've expanded to Brazil, a sort of something we've had to handle, and hopefully we've done it well, and hopefully we have something that's useful to Brazilian lawyers and others. So yeah, I mean, I'll pass over to Georgina now just to speak a bit more to some of the sort of importance of capacity building for practitioners. But I think there'll probably be a link posted in the chat. Would really encourage you to check out the Law and Climate Atlas. Would love to hear any thoughts, opportunities for collaborations, even criticism. Thank you.
Absolutely. Thank you so much, Nick, for talking us through the Atlas. and just also for your partnership of the last, I think, over 3 years, starting off with the UK, then we went into the US edition, and now Brazil, and the EU is coming soon, and then I really hope we can take this truly globally. And also thank you quickly to all the panelists and attendees. It's such a privilege to be with you today. And, you know, being in London at the moment rather than Berlin, it's nice to feel really involved and tapped into these conversations, so thank you. As Nick mentioned, I just want to quickly reflect on the importance of climate capacity building more generally for the legal profession. So at the Net Zero Lawyers Alliance, at the NZLA, capacity building is one of our 3 strategic pillars. And this has been the case since our launch back at the Glasgow COP. So we've really been on a mission to put what we call the climate brick in the brain of all lawyers. Because we believe that once the brick is in the brain, it unlocks the potential to find net zero alignment across all areas of the law and green financial flows. So I think there are a lot of incredible training materials out there on climate science, on commitments, on policy and economics, and all of these are so important for everyone, including lawyers. But what I really love about the Atlas, and what at the NZLA we really try and shine light on, is that bridging of the gap between the why and the what. So why do lawyers need to understand climate? Why do they need to understand the science, the commitments, the policy, the economics? And what they need to understand. And I think the Atlas just makes this crystal clear. It maps right across different practice areas. How is climate impacting that practice area, and how, as a lawyer of that practice area, can you play a role in climate? So it's a beautiful sort of double-sided coin, you know, two sides to sort of the same coin. And I think personally, and you know, the perspective of the NZLA is that this understanding, it is not just the right thing to do, it is the really smart thing to do. So like Nick said, we encourage you to check out the Law and Climate Atlas. And then I do also just want to plug another capacity building tool that I think is particularly helpful in that bridging of the gap, the why and the what. And that is the transition framework for commercial law firms. This is available on the NZLA website, and it provides guidance on the steps that commercial law firms, so it's a bit more specific than the Atlas, so the steps that commercial law firms can take to manage firm climate-related risks, and again, unlock opportunities to facilitate the global transition to net zero. So I'll leave it there, short and sweet, but thank you again to Nick and all the panelists and attendees. Thank you.
Thank you so much to our keynote speakers. It's a brilliant initiative that we are all looking forward to learning more about and joining as well. So it's my honor to introduce our panelists. Our first panelist is Advocate Zenaida Musa Wadiwala, is an admitted attorney, conveyancer, and notary of the High Court of South Africa. She's also a lecturer, legal researcher, and lead in African climate law, Mandela Institute, University of Witwatersrand. Our second panelist is Advocate Hafiz Khan, an advocate at the Supreme Court of Bangladesh, founder and director of the Center for Climate Justice in Bangladesh, coordinator of the Loss and Damage team of the LDC's climate group at the UNFCCC, and co-chair of the Executive Committee of Warsaw International Mechanism for Loss and Damage at the UNFCCC. We also have Professor Carolino Garrido, a legal researcher specializing in Brazilian environmental law and serves as research coordinator of the Law, Environment, and Justice in the Anthropocene group. She acts as Brazil's national rapporteur for the Sweden Center's peer review network of climate litigation and for BIICL's project on corporate climate legal tactics, focusing on climate litigation, climate justice, the Anthropocene, and environmental law. We also have Professor Demalam, who is kindly joining us all the way from Bhutan, where it is very early in the morning right now. She's an associate professor at Jigme Singye Wangchuck School of Law. Her recent research focuses on access to justice in Bhutan, as well as the intersection of climate change and disability rights. Her work has been published in leading academic journals, including the Asian Journal of Comparative Law and the Forum for Development Studies. Currently, DemEd is part of a multidisciplinary research team at JSW Law working on the project Clean Energy for Better Air, Health Impact and Inclusivity, supported by ICIMOD. She was also a member of Bhutan's national delegation to COP28 in Dubai. Advocate Ayman Sherkawi will be joining us shortly as a director at the Hassan II International Center for Environmental Training and coordinator of the Mohammed VI Prize for the Climate and Sustainable Development in Morocco, and is joining us from COP30 in Belém. He also serves as lead counsel for climate change in the Center for International Sustainable Development Law, among many other distinguished international leadership positions in international policy, law, and action, and has kindly guided us through nearly a decade of climate law and governance days. Lastly, we have Advocate Andy Rain, who is the Deputy Director of the Law Division at the United Nations Environment Program. He helps lead a global team in the progressive development and implementation of environmental rule of law. He is unable to join us in person today, but has submitted a video that we will play at the end of the panel. Can we call on Advocate Zenaida?
Greetings from Johannesburg, and thank you so much. It's a privilege to join this roundtable alongside distinguished colleagues and to contribute to a conversation that sits at the heart of Paris Agreement implementation. Climate ambition is built in negotiation halls, but it is delivered through institutions, through law, governance, and the people who give life to them. Without strong legal capacity, even the most ambitious NDC remains aspirational rather than operational. Climate governance is not only a technical or environmental challenge. It is fundamentally a legal and an institutional one. About how we design, coordinate, and enforce rules that translate political ambition into practical outcomes. In many ways, strengthening climate law and policy capacity is the hidden infrastructure of climate ambition. This is because it ensures commitments survive political cycles, it gives investors confidence, and of course, it anchors accountability. The three topics I will be discussing for the next few minutes are firstly, why strengthening climate law and governance capacity matters, including talking about leading examples and lessons learned with African perspectives. Secondly, the role of academia and professionals. And lastly, innovative tools for high ambition NDC implementation. So why is strengthening climate law and governance capacity so important? Because at its core, the Paris Agreement depends on national legal systems. Of course, NDCs require credibility, and they only acquire that credibility when they are embedded with clear domestic legal mandates. Climate laws create an architecture of credibility. They define who must act, how they must act, and of course, how progress is tracked. This means that when capacity is weak, implementation stalls. But when capacity is strong, three things become possible. Number one, coherence, aligning international commitments with domestic policy, extending into budget cycles, planning frameworks, and regulatory systems. Number two, predictability, the long-term stability that is needed by investors, communities, and even regulators. And number three, accountability, through monitoring, reporting, verification, judicial oversight, and transparent review mechanisms. In the Global South, these capacity questions are heightened. Many countries face structural governance constraints, such as under-resourced regulators, overlapping mandates, and competing development needs. Yet, the marginal impact of each institutional strengthening is enormous. A single well-designed regulation or institutional reform often unlocks disproportionate climate benefits. At the same time, global North countries face their own governance challenges, such as balancing ambitious climate laws with legacy fossil fuel infrastructure, addressing internal political polarization, and ensuring that their domestic policies do not export emissions or impose inequitable burdens on developing countries. This asymmetry in capacity, responsibility, and political constraints shapes how climate governance evolves globally. In essence, then, climate ambition is delivered through national institutions, through the rule of the law. Of course, when it comes to examples and lessons learned from Africa, Kenya serves as quite an encouraging example because with its 2016 Climate Change Act, which was one of the continent's first to embed the NDC process into domestic law, it therefore created institutional structures, reporting obligations, and it mainstreamed climate into planning. That was quite phenomenal back in 2016. And just this year, South Africa adopted its Climate Change Act. This act establishes a national system for greenhouse gas emissions mitigation, adaptation, planning, sectoral emissions targets, and carbon budgets. Importantly, the South African Climate Change Act gives legal force to coordination mechanisms across national, provincial, and local governments. This is important because it reflects the complexity of South Africa's multinational governance systems. So these African cases highlight nuances that are often underappreciated in the global North contexts. For example, the centrality of development priorities and energy access, the importance of informal governance, customary systems, and local authorities, the reality of capacity constraints and resource scarcity, and of course, the need for legal frameworks that are not just ambitious, but they need to be implementable in differentiated socio-economic contexts. Across contexts, several lessons remain consistent. Laws require institutions because climate law is only as strong as the judiciary, the regulators, and the subnational authorities responsible for enforcement. Cross-sectoral integration is essential, and this is because climate mandates must be woven into energy, transport, mining. And lastly, participation matters. Going into the role of academia and professionals, academic institutions and legal professionals are powerful multipliers of climate governance capacity. Universities are not simply places of learning. They are engines of legal innovation and civic mobilization. The ICJ Climate Advisory Opinion illustrates this vividly. The original call came not from diplomats, but from university students. It began in a classroom, demonstrating the catalytic power of academic spaces. Academia also strengthens climate governance through doctrine and technical expertise. Scholars regularly act as friends of the court, providing amicus briefs that enrich judicial reasoning with science, comparative jurisprudence, human rights analysis, and state practices. We've seen this in the regional and international advisory opinions. So this role will actually be very vital and we're all very excited about the upcoming African Court on Human and People's Rights Advisory Opinion on climate change. And as we speak, academic networks across Africa are preparing submissions to help articulate continental perspectives on state obligations, the right to development, equity, and just transition pathways in African contexts. So academia builds long-term capacity. It integrates climate governance into legal curricula. It facilitates South-South and North-South knowledge exchange, just to name a few. Time constraints, I could go into more on that. And just to conclude, talking about innovative tools for high ambition NDC implementation, there are a number of emerging tools can accelerate implementation. And due to time constraints, I won't go into that, just to say, or just to name two of them: climate legal readiness assessments, climate aligned procurement and contracting. We heard now about the NIC's climate law atlas. So these AI and open data tools are so important in this context. And with that, I close. The strength of our global climate response will depend on the strength of our legal and institutional foundations. Thank you so much.
Thank you so much. I will now turn over to Advocate Hafiz Khan.
Thank you, moderator. Good evening from Belém, from COP30 venue. So, colleagues and friends, I was listening the keynote presenter's presentation very carefully, and I do really appreciate for your very insightful presentations. Also, I do appreciate Advocate Zunaida, who provided a nice overview on the rationale for legal innovations in institutional strengthening, collaborative leadership, accountability and transparency, also judicial oversight. I think Advocate Junaida covered Hughes issues. So, colleagues, I just came out from a negotiation drafting session just to attend this interesting event. So, let me tell my perspective. I'm involved with this negotiation process. It's now more than 15 years, but the global community is involved with this process. Now it's more than 30 years. Within these 30 years, what we got actually, what we achieved, we adopted the convention in 1992, then the Kyoto Protocol in 1997. Unfortunately, from Kyoto, we do see a paradigm shift from obligation to voluntarism throughout the adoption of the Paris Agreement. The Paris Agreement, it gave us new ideas, so-called idea of NDC, nationally determined contribution. We also call so-called bottom-up approach. At the same time, under the Paris Agreement, we are now all developed the national adaptation plans. Now we are thinking about the national loss and damage plan. Now, challenge is you have the NDC, you have the National Adaptation Plan, now the National Response plans at the national level. So there are so many plans, policies, strategies now exist at the national level aligned with the Paris Agreement. Now, concern is the implementation. Now, let me give an example, the implementation scenario within the context of loss and damage. Colleagues, you all know that we got the loss and damage fund, that is called Fund for Responding to Loss and Damage, FRLD, where we agreed two-pronged approaches, that is trigger-based and the programmatic approach. What is trigger-based? Trigger-based is you need to provide financial resources to the vulnerable communities soon after an event like flood, cyclones. You need to provide them humanitarian responses, including medical services. For example, for a pregnant women, she needs a special care, right? On the other hand, the programmatic approach, particularly for the slow onset events and non-economic loss and damage, we need to develop short-term, mid-term, long-term programs, not the projects. And we also agreed in the modalities for the loss and damage fund, we want the direct budget support. To get the direct budget support, we need to develop this sort of program so that this fund can provide you direct budget support. But problem is that currently the modalities we are developing that requires the functional equivalency to access this fund with the direct budget support approach. Our ministries, they need to develop, they need to clarify their functional equivalency in line with the multilateral development banks. So this is the time to develop at the national level the policies, plans, programs, finally the legal instrument. One of my colleagues already said legal instruments and policies, they need to deliver through an appropriate institutional architecture. So at the national level, to the local level, we also need an effective and efficient institutional structure so that it can deliver the needs of the vulnerable communities at the local level and at the national level. So then the question arises capacities. To be honest, particularly least developing countries, we don't have the capacities to take this holistic institutional legal reform initiative and to develop required legal, institutional, and policy structure back home. That's why one of my colleagues mentioned that this is the time to collaborate among the academics, policymakers, practitioners, NGOs, also communities. So there is a need for a multi-stakeholder governance approach. That's the question comes for innovation, legal innovations, institutional, architectural innovations that can really help us. I do appreciate really CISDL that is taking huge initiative to build up the capacities from particularly for the vulnerable developing countries to build up the legal capacities that would be really useful. This is the time to take such initiative to build up the capacities of the policymakers, practitioners from the developing country, and CISDL is doing in a very innovative ways. I would like to thank you, CISDL, also who listened to me, and all of the panelists and presenters. And I'm very much looking forward to exchange our views within the next few courses. So who will be at the COP? I will be very happy to meet in person to continue our discussion. And moderator, thank you so much. And colleagues, if you allow me, I would like to go back to my drafting session, but still I'll be online. If there is a burning question, I can chat and I can respond. Thank you so much. Thanks.
Thank you, Hafiz. And now we're having a advocate, Ayman.
Thank you very much. Hello, everyone. I'm also just like my brother Hafiz in the same situation. I hope you can hear me well enough as I'm in the COP venue in Belém. Thank you very much for including me in this important session. It is a pleasure to join you today and reflect on an issue that, in my view, ultimately determines our NDCs, whether our NDCs succeed. The capacity of our local institutions, especially local authorities, universities, to move from ambition, and at the national level, of course, and beyond that, to move from ambition to implementation. Ambitious targets matter, but only we make progress when the people closest, we only make progress when the people closest to the ground are trained, equipped, and confident enough to act. In Morocco, at the Hassan II International Center for Environmental Training, under the patronage of Her Royal Highness Princess Al Hasna, we have spent a few years, more than a decade, strengthening exactly these type of stakeholders. It began in 2013 with the development of the National Bilan Carbon tool, carbon accounting tool. That was the first in Morocco, the first in the Arab world, and the second in Africa, and the adaptation of several hundreds of Moroccan-specific emission factors. These technical bases may feel far from local authorities, or local realities rather, but in practice, it is what allows a municipality, a university, or a regional council to provide credible baselines and design realistic climate action. Over the years, we built a national training ecosystem with ADEM, ABC, ministries, CGM, AME, Imanol, etc. By 2022-2013, the ecosystem has become one of the largest in Africa. Over that period, we delivered dozens of days of structured training, reaching hundreds of participants, many from local authorities, universities, engineering offices, and public institutions. Knowledge acquisition reached an average of 63%. Through that program, and in addition, training the trainers program, several hundreds of experts, African experts, had their capacity built further, and they were able to then support national actors or regional actors when it comes to opportunities connected to, for example, climate finance or at the national level in Morocco. In 2024, and that's why I'm referring to the national level in Morocco, we further decentralized our approach by organizing regional training sessions all across the country. We also worked through another of our programs that we have in partnership with the United Nations Environment Program, and that is the African Green Universities and Youth Education Network. More than 100 students and academics to better understand the methodologies linked to carbon accounting based on international standards and approaches and methodologies that are contextualized to African constraints and opportunities. We believe these sessions are particularly important because universities are campuses, but they are also knowledge hubs for entire regions. And we made significant progress on the first national MOOC on decarbonation, which will directly support local authorities and will be launched by the end of this year. In 2025, we further developed, again, our architecture when it comes to training through different modules of training again, hundreds of participants with a strong participation of local authorities and again, academic institutions with an average knowledge gain of over 51%. We had support with from GIZ. We also work in close collaboration, of course, with our national partners to deliver advanced, for the first time, ISO 14064-3 verification training for 50 of the leading experts in Morocco. Overall, across the decade, we have trained directly more than 1,300 people in these programs and indirectly thousands more. This focus on territorial institutions has been central to our climate finance training program. Through the Foundation's Climate Academy, we have trained again more than 1,000 people from local authorities in terms of building projects that are eligible to climate finance at the national or international level. This work proved extremely useful. We've been doing that since 2021. Most of the projects that you can see in the Moroccan NDC 3.0 at the regional, local level actually came through the programs that we put in place, showcasing concrete outcome. Also, when it comes to the NDC 3.0, we supported youth engagement on a national scale. More than 1,000 young people participated in consultations, and that resulted in a concrete outcome formalized in the Moroccan NDC 3.0, where the priorities that they are notified are formally reflected. Adaptation, of course, is very important, a particular priority in Morocco and Africa. And earlier, we did a training program earlier this year, we did a training program at the center with the Africa Adaptation Initiative on adaptation metrics and measurement. And the outcome of that training program and reflection was presented here in Belém just yesterday. When I look back on all this journey, and in the interest of time, I'm not going into the full details of that, a few things become clear. Sustained investment in local authorities and universities deliver results. Localization matters. Adapting hundreds of emission factors is meaningless unless territorial actors know how to use them. Youth and universities are not future stakeholders. They are current partners who bring energy, knowledge, and continuity. And digital training tools, and the day that we are all part of today is a beautiful example of that, allow us to reach regional and academic communities faster and at scale. Africa has the talent, the institutions, and above all, the youth to lead on climate implementation. The priority now is ensuring that local authorities and universities, those who shape climate action every day, have the skills and tools needed to transform commitment into results. Our experience shows that when these actors are empowered, the path from ambition to impact becomes much shorter and sustainable. Thank you.
Thank you, Amen. That was so nice to hear you. And next is my colleague here from Brazil, Professor Carolina Garrido.
Hi, everyone. Thank you, Layla, and everyone for having me here. I'm also in Belém, and I welcome everyone who is here in person to our beautiful country, and everyone that's not, that you should come, not only for the COP, but also to getting to know a little bit better our country. So I was delighted to be invited to present here and talk a little bit about one project I was involved in, which is called the NDC Align, and it's exactly a tool made up from academia to think about the implementation and the translation of the NDCs into domestic law. And so I'll speak a little bit quickly on the overall idea of the tool, but also I'll try to share my screen and show a little bit to you all as well. This was a tool developed by Grantham Research Institute at London School of Economics in collaboration with Climate Policy Radar, Juma at PUC-Rio, which is my research group, and also La Clima, which are two Brazilian research groups. So we're in this intersection between the international and national. And the idea is that it's a tool for mapping the alignment of NDC commitments from a country to its domestic law and policy. So we know, and we've been talking a little bit about this already in the session, that to implement the Paris Agreement, we do have like these two big critical challenges. And one of them is the ambition gap. We know that we have a big gap between what countries have promised in the NDCs and what we need to achieve the objectives of this treaty. But we also have an implementation gap. And I think this is the main question here for our panel. This is the difference between the commitments and the policies that are actually enacted and enforced for us to deliver that commitment. So our research was based on understanding that to have a better look at this second gap, this implementation gap, we need to look at policy outputs, which are the law, regulations, plans, and policies that the government produce to translate this commitment into action, and also policy outcomes, the real world effects on emission reductions that these laws might achieve. So our tool is more focused on this first sphere of policy outputs. So we are all legal researchers looking at the law, regulations, and plans put in place in one country to implement its NDC. So our pilot country was Brazil, since we're a research group in Brazil, and with all this context of COP30 happening in Brazil. And we try to look at four main areas that we believe are quite important to understand these policy outputs. And I think now it would be better to just show a little bit the tool and a little bit how we go through these four elements. So I'll try to just share my screen over here. And is everyone able to see it? Okay, so here it's what the tool looks like, and you can find it easily on the internet. I'll also put afterwards the link in the chat, but it's online and everyone can see. And the first module of this research was based on an NDC overview, which we tried to present the Brazilian NDC, but also, and this is available in English and in Portuguese. But also we can have a look at the NDC and the domestic high level view of the the status of the NDC, but also what we have in domestic policy and the NDC on long-term economy emission reduction targets, and also for adaptation. So this is a first overview of the NDC. And the second module, which is kind of the heart of the whole project, we look at institution and processes. And we understand that to successfully implement an NDC, we need to develop and successfully implement this whole climate governance. So we try to look at different aspects that we believe are really important to understand this, and different institution and processes, and you can see them over here. And we try to respond to different questions on them. So I'll just take integration for an example, something that's already been mentioned here as well. So we have different kind of questions that are being asked for this. We use a prior database on climate laws of the world that was developed by the LSE and Grantham Institute, and we try to answer these questions based on the laws of the climate laws that a different country, that here in our case Brazil has. So Sometimes we won't have an answer, so no evidence can be found. Sometimes we do find some law that brings some kind of mechanism to answer that. So then we have a bigger answer, and also we flag what source we used. And here you can have an overall view of the different areas of each sector that we are considering, and also in which ones we found something in law, policy, or practice, and the ones that we have some development going on, eventually something that's only said in the NDC, or something that's only under development. And this will change we can, in these different areas of governance. Also, we, on a more material side of it, we also had a look on plans and policies. So we had a first module here in plans and policy to look at cross-cutting policies, but also sectorial mitigation and adaptation plans. These here in the Brazilian case, we follow our NDC and our different areas of plans for mitigation and also for adaptation. Understanding that to translate this NDC interaction, we need a specific look at the different sectors and how the countries are developing these plans. And last but not least, as we heard a little bit about South Africa as well, looking at Brazil, which is a really large country and also has a federalist system, we had to look at a subnational action. So we also had a quick look on states and how the states' policy, climate policy are developing. So we adapted a little bit of the questions we made at a federal level for the Union, for Brazil as a country, and also implemented it for the different states. So you can also click in different states and have a quick look on how they're developing their policies. So I'll stop sharing now, and I'll thank you very much for this opportunity to presenting the tool. It's available online, and I'll send the link, and I invite everyone to have a deeper look at it. Thank you.
Thank you, Professor Carolina. I am absolutely going to check it. What an important data. Oh my God. And so the next one is Professor Dima.
Hello, everyone. It's nice to meet everyone, and thank you for the invitation to contribute to this important dialogue. It's early morning here, so good morning, good afternoon to everyone from everywhere. I'll speak from the context of Bhutan, a small Himalayan kingdom that is proudly carbon negative, and where our constitution requires at least 60% of our land to remain under forest cover for all times to come. And this constitutional commitment reminds us that ambition alone is not enough, and it must be supported by institution, people, and knowledge. And that's why very important that capacity strengthening is central to implementing the Paris Agreement. So in the next 5 to 6 minutes, I'll try and answer 3 questions: why capacity matters, what we have learned here in Bhutan, and the role of academia. And firstly, I think capacity is what turns aspiration into action. Especially here in Bhutan, our strong environmental values translate into real outcomes because we have invested in laws, regulatory system, community forestry programs, protected areas, and monitoring mechanisms that allow implementation to happen at ground level. And therefore, capacity is a bridge between policy and a ranger in a forest, between national commitments and a local stewardship, and a pledge between an NDC and a real resilience in a village or a community facing climate risk. What have we learned? I think one of the most important lessons from Bhutan is that durable climate action requires durable institutions. A key innovation for us has been the Bhutan for Life initiative, an endowment backed financing mechanism that secures long-term funding for our protected areas and biological corridors. And this ensures that conservation and climate action continue steadily regardless of political or funding challenges. And we've also invested in community forestry and benefit sharing arrangements where local people are partners and not just there as stakeholders. And Bhutan, as a mountainous country, adaptation is central for us. I think we've already spoken, as already spoken by the earlier speakers about the importance of adaptation. I think glacier, lake outburst, flood, ever-changing rainfall now, and water stress threatens our livelihood. And our response has been to strengthen the early warning system, having disaster law is in place, land use planning, and local preparedness. And here too, I think capacity is not just seen as technical expertise, but rather as governance, coordination, and the ability to act together in real time. The role of academia, I think, allow me to turn to how academic institutions can scale up efforts. And drawing from our experience at Jigme Wangchuk School of Law, Bhutan's first and the only law school, we have a graduate program designed specifically for climate implementation. We offer a specialized LLM and MLS in international climate change and environmental law, designed precisely to build the human and institutional capacity needed to implement the Paris Agreement. Professor Mary Claire is one of the faculty members for our LLM program. And the program blends international and comparative law with Bhutan's legal, cultural, and ecological context, integrating law with science, technology, indigenous knowledge, and the values of cross-national happiness, the development or the guiding philosophy of Bhutan, as some of you may already know. And JSW Law, as I mentioned earlier, is the first and the only law school. We are only 11 years old, and we chose to inaugurate this graduate program on international climate change and environmental law at this pivotal moment to address the urgent and timely challenges facing our planet. Bhutan's unique position as an environmental champion, its carbon negative status, and its profound vulnerability to climate impact makes it ideal living lab for rigorous study and practical learning. So the program leverages this convergence of global importance and local experience to train lawyers and other professionals who can navigate boundary, climate governance, biodiversity protection, and sustainable development with culturally informed insights. And so basically, we emphasize Bhutan as a case study, allowing students and professionals to examine both our environmental successes and the challenges faced by a small mountainous developing country. And we also offer a dedicated course on ethics for environmental lawyers, emphasizing again integrity, responsibility, and the duty to represent both people and the planet. And experiential learning is central to the program. Students take part in the field work, join the environmental law clinic, the undergrad environmental law clinic, supporting the government, ministries, communities, and CSOs to live issues from drafting regulations to advising on climate adaptation and ecosystem services. So in this way, the LLM and the MLS program help build a community of practice, producing graduates and professionals who are globally literate, locally grounded, and ready to contribute immediately to the NDC implementation. And we also have what we call the Climate Change and Environmental Law Center at the law school. And the LLM program is strengthened further by having a climate change law and policy project which operationalizes research, innovation, and policy collaboration. And in the last few years, what we've done is we've reviewed Bhutan's climate laws and policies, is developing a climate policy and legislation analysis tool to ensure new policies are climate resilient and justice oriented, building regional research networks, and we've been hosting national and international climate law forums in the last few years. So through these projects, academia becomes a policy co-author and not only a commentator. So in conclusion, I think my 6 minutes is almost over, I think. I just want to inform everyone here that at JSW School of Law, we believe that no single institution can advance climate ambition alone. We look forward to working hand in hand with each one of you here, sharing knowledge, co-creating tools, strengthening one another's capacity so that our collective efforts deliver real and enduring climate impact. Thank you. And thank you for giving me this opportunity. Thank you.
Thank you, Professor Dima. And next, we are going to play a video of our next presenter, which is Andy, who wasn't able to be here today. So he sent us a video.
Quickly get a thumbs up that you can see the video.
We can. It's just not playing.
Fantastic. I'll play it now. Thank you.
Thank you.
Hello, everyone, and warm greetings from Nairobi. It's a pleasure to join you for this legal roundtable and to offer a few brief closing reflections. We all know that climate ambition is only as strong as the laws and the institutions that give it force. The Paris Agreement and the broader tapestry of international environmental law, it provides a powerful global framework. But it is through national legal systems that ambition truly becomes reality, where commitments are translated into rights, to duties, where institutions give them life, and where the rules of the game are clarified and enforced. Colleagues, we all understand the scale and the urgency of the challenge. UNEP's emissions gap report, published just recently, reminds us that even if all current NDCs are fully implemented, the world is still on track for 2.3 to 2.5 degrees of warming. We've reached a point where every fraction of a degree matters. And this underscores one simple truth. Strong climate law and governance capacity is not optional, it's essential. Across the world, UNEP has had the privilege of supporting many countries to strengthen and to implement their climate legal frameworks. We do this under something called the Montevideo Program on Environmental Law. This is a 10-year intergovernmental initiative with environmental rule of law as its compass. We're seeing tangible progress in countries that we have been supporting. An example, Chile's framework law on climate change. It now mandates sectoral plans across ministries. Thailand's Draft Climate Change Act. It links climate planning directly to national budget processes. And Zimbabwe's Draft Climate Change Management Bill embeds rights to participation, to information, to education, making climate governance more inclusive and more rights-based. Alongside these legislative reforms, UNEP also works to strengthen judicial capacities. Our global climate litigation report identified more than 3,000 climate cases in 55 jurisdictions to date. From Pakistan to Finland to Papua New Guinea, courts around the world are now holding both governments and companies to account. And as you know, national jurisprudence has now gone global. And it's hard to overstate the significance of the 3 advisory opinions delivered by ITLOS, the ICJ, and the Inter-American Court of Human Rights. I know many scholars in this session are helping the international community to digest and to use these landmark opinions. So it's in that context, let me conclude by recognizing the vital role of academic institutions and professional associations. In UNEP, we value these partnerships deeply. They help us deliver our work. They provide the intellectual rigor that strengthens our work and continually challenges us to think differently. Brilliant minds across universities and legal communities are reimagining climate governance, exploring what works, what doesn't work, and what must change to meet the urgency of our time. At a practical level, we've collaborated with institutions in every region to integrate climate law into curricula, to foster regional lecturer networks, and to develop open access digital legal tools. So colleagues, None of this can succeed if we operate in silos. So I warmly invite anyone in this forum, from academia and beyond, to reach out to UNEP to explore new partnerships for building capacity for climate governance and NDC implementation. We would welcome this. Thank you very much.
Thank you so much. We will now move on to the question and answers. We have the third plenary for Climate Law and Governance Day has been postponed to 2026 for time to have more time for discussion. So we are very blessed that we have an extra 15 minutes or until 5:10 p.m. here in Brazil for more questions and answers. So for if any of our participants have any more questions, please do put them on the Q&A, stating your name and where you're from. So I'll start with two questions that are quite similar. The first one is from Tesfaye Abate from Ethiopia. What mechanisms would be more appropriate to upgrade the capacity of judges in particular in developing countries? And next, which is a little bit related to this question, is from Valentina from Italy. From Kate from Georgia, who is asking how to increase the capacity of lawyers who are doing to help them for emerging professionals and those of them who are for people who are looking to refocus careers towards climate protection and SDGs. Who can we turn to Advocate Zenaida?
Sure, Railla, thanks. So those are pretty broad questions, and I think they could best be answered within the context of everything that we spoke about today. The entire climate governance framework, once that is strongly established in a particular jurisdiction, it adds to the jurisprudence, and lawyers and judges can empower their climate knowledge on that basis. Of course, what Andy Rain just spoke about now, alluding to the regional and to the international jurisprudence that's growing. And I think that too, powered or empowered by academia stepping in. And I think once again, I'm referring to how Andy Rain spoke about how people on this call are empowering how these international and regional climate advisory opinions can be used within perhaps domestic or national litigation, climate litigation. So I think although governments might be overwhelmed, that would possibly, be a feasible and a foundational starting point for improving capacity for lawyers and for judges. There's, of course, a wider way that we can look on that, perhaps training officials and resource regulators. And I suppose this does differ from country to country because looking also at the UNEP report that was released recently, and he spoke about 55 jurisdictions, and he mentioned quite a few. It's quite surprising though, in that report, I was just reading the top 10 jurisdictions, and South Africa having particularly 11 climate litigation cases at the moment. It's not even featured as a jurisdiction in the top 10. So Africa is not, it's nowhere near. So Asia, Africa, if you compare all the jurisdictions, they don't feature anywhere. We know USA is the first, UK, Australia coming in second strongly, but there are jurisdictions where it needs, development is needed, and building and upgrading these type of skills is the way to go, I think. I hope that answers the questions.
Would anybody else want to jump in on those questions? If not, we can go to the second set of questions. Layla?
Yes. Well, I read here a very interesting question from Italy, right? From Valentina and the students from Italy. And they're talking about, I think they're more like reflecting about the NDCs and the commitments that are there and how to achieve. They're mentioning that they think they are somehow broad, and that actually affects, the achievement of the goals, and if that's a problem. And to me, it's a brilliant question, because it is, to me, my vision, a problem here in Brazil, for example. And I think that at the same time that we cannot, the government is unable to establish mechanisms in the NDCs, that's something that's actually being an obstacle to the achievement of the goals. And I think that, yeah, that's the importance of the academy, because we, with data, just like the one presented by Carolina, we can show the government ways of getting to achieve these goals, because there is a lack of information and speciality within the government here in Brazil that allows them to achieve and to establish efficient ways of achieving the goals that, Brazil has committed, within the NDCs. So I don't know if I answered. It's more like a reflection. And the fact that we are now hosting this big event, and specifically in Belém do Pará, is something very interesting and very concrete for us to think about this issue. As in order to have the event, there was a demand of devastation of the forest around the area, that the event's taking place, which is something that is against, the NDC commitments and the achievement of the goals that we have there. But, I think that the problem here we have, besides, the lack of, data and information by the government and mechanisms, is also the political interest, and the fact that the public policies, they hardly, are able to go against these political interests. So sorry if I talk too much.
I was just wondering if Dema is still with us, because your perspective on this question might be quite interesting. You introduced your presentation by saying that you're from Bhutan and you're net zero. So perhaps if you're still with us, I know it's very late for you now, perhaps 2 or 3 in the morning. But if you'd like to weigh in, I'd be interested to hear.
Professor Dema? That would be interesting. Yeah, I don't think she's with us.
Perhaps unfortunately not. Maybe we should move on.
Perhaps I can just say something in this regard about implementing NDCs, and hopefully while we're waiting for Professor Dema to join us again. I just wanted to point out that you all must be knowing that the NDCs, the second NDCs, were due to be submitted by February this year. And obviously February came and went, and most countries hadn't yet submitted. So implementation is, of course, a big problem. South Africa has fortunately submitted by September. But the questions in this program got me thinking, and I was looking at how can innovative tools actually support or strengthen NDC implementation. And I think there's so many different ways. Of course, climate-aligned procurement, contracting frameworks, that goes without saying. But looking at something innovative, and I think we go to these open data portals where you can increase transparency, and that would rather, improve instead of bypassing domestic situations, looking at climate legal readiness assessments, that map institutional gaps. So those are, I think, maybe a little bit speaking to what the question was asking. And then I also want to highlight that we need to ensure implementation remains equitable, especially in continents like Africa. So without going into too much detail, I just wanted to highlight that. Thank you.
Thank you so much, Zenaida.
Yeah, so I don't see Professor Dema back yet, but we have a question here from Asif Ansari from India. So we had a great keynote presentation from our partners at DemEd Global, who's objective is really to democratize climate education through online training. But the question here is, so since we are moving to online or virtual mode, how do we that produce a lot of e-waste? How do we tackle this scenario, and how do we sort of mitigate this issue?
I'm sorry, it produced a lot of, sorry, I didn't catch that.
E-waste.
E-waste, right?
Yes.
Okay. I think for sure, like for virtual events, there would be like say carbon emissions involved, but compared to something that is like in-person event, I would say the perks would still be like more convincing compared to doing or delivering the trainings in person, because like considering the global reach that we have right now, and it's not just about flying in the people, it's also about ensuring that that kind of high quality education is actually accessible to for example, not just like people who are currently serving as judges or government officials. It could also be someone like a young activist from indigenous group or some very remote villages who may need to, for example, go to a community center to actually get access to Wi-Fi. So that kind of virtual delivery actually kind of like maximize the chance that we can extend that kind of global outreach and deepen that kind of accessibility of the original mission of DemEd Global. So yeah, so I would say that would be the response that I have for the question. And if Joe, if you have anything to add, please feel free.
I believe Nick has. Sorry, Joe.
Sorry, yeah, I mean, I don't know if it's really answering the question, but maybe to add another element to this question on e-waste and sort of the move to virtual, I think something which we've been increasingly hearing about is sort of the rise in AI, in particular large language models, and their use in law firms and in education. And so we've been hearing about and sort of been asked questions about, well, how can we integrate our resources into AI? But that comes with other environmental risks. As many of you probably know, AI poses essentially just uses a large amount of energy. So it's not that we have a clear answer to this, but I think this is another thing which I think the sort of legal profession and those involved in sort of capacity building within it will have to tackle is how can we make sure that our resources are being integrated in the tools that law students, lawyers, and others are using, but also being conscious that when we do that, we might be sort of, at least in part, driving some emissions, which also aren't necessarily traditionally accounted for. So this sort of energy used to train artificial intelligence models, for example, isn't often accounted for. So I think it's sort of a very interesting challenge, and I suppose I wanted to bring it up because it's related to that e-waste point, and I think it's something that law firms and sort of academic institutions are going to have to grapple with soon.
Joe?
Thank you.
Yeah, I don't have too much to add. I think that Carter and Nick did a great job of answering that question. And I'm really glad that the question was asked. I know that these questions around AI and e-waste are sort of as online education and the rise of AI are in their nascence somewhat. So perhaps these conversations about how we can better handle e-waste and the ethics of using AI for the particular kinds of online education we do are ones that will evolve into sort of the language of accessibility and sustainability within the programs that we run as well. So I'm really glad that the question was asked.
Joe, I see that Professor Dema is back. Would you like to repeat your question as the last question to this session?
Yes, thank you so much, Professor Dema. We had a question in the chat about, sorry, I'm just going to scroll back to it here, from Valentina in Italy. Don't you think the issue with NDC implementation lies within the NDCs themselves, in the sense that they are too wide in scope and too vague in what is requested to countries, i.e. just commitment to policies without proper reporting and quantifiable evaluation required to track progress towards the target set in the Paris Agreement? And I thought that it would be particularly interesting to hear from you in contrast to Layla's reflections on this, because you started your presentation with, I'm from Bhutan and we're net zero. These reflections might be quite different to what Layla was speaking to about Brazil. Please.
Oh, okay. Sorry, the question was asked earlier. I had gone to the restroom. So Bhutan is carbon negative is what I had shared, and sorry if my answer doesn't make sense. I'm now starting to feel the sleep really overpowering me. But Bhutan, as I mentioned earlier, we are very proudly carbon negative, but that does not mean that we are exempt from challenges of NDC implementation. Our NDC is also still very broad in place, especially on adaptation. And we face the same issues like many other countries do, right? Translating ambitious commitments into specific measurable actions with clear indicators and responsible agencies. Being carbon negative also requires a continuous governance, as you all already know: forest monitoring, land use planning, climate finance, and strong data system. And these demand capacity, coordination, reporting, which is not easy for a small country with limited resources. We are trying our best, but still there are limitations. So yes, even Bhutan feels the limitation of NDC structure. Experience has shown that ambition must be matched with clarity, institutional capacity, and long-term support to maintain and strengthen the progress we have. So, in short, what I am saying is that we are proud to be carbon negative, but maintaining the status and building resilience requires clarity and accountability, capacity that all countries need. It's an achievement, but implementing NDC is the work. Yeah, I don't know if I made sense, but yeah.
Yes, you did. Joe would like to add something. We have just 1 minute, right, Railla, or no? Pushing the boundaries?
We can go to closing now, I think, unless Joe has anything to add.
You do have an extra 10 minutes because we have been given extra time by the organizers.
That's great.
Short plenary will be held in 2026 in order to allow extra time for discussion in the different sessions. So you can go until 10 minutes after the hour. I hope that's helpful for your session.
Yes. Thank you so much, Professor Marie. So Joe, go ahead. I don't know if you want to add something to this question or...
No, sorry. I just wanted to circle back to the question to direct it to Dema for her interesting insights from Bhutan, but thank you.
Good. Railla is with you.
Okay, I'm looking through the questions now, and I think we pretty much covered everything, unless anyone has some closing remarks or some
it would be terrific to do a round of
later.
closing remarks with key takeaways. That's an excellent idea.
Railla,
yes. Advocate Zenaida?
I just saw a question from Professor Marcus Gehring, and I would like to answer that. His question is, how can we strengthen capacity on climate law and governance in very remote places? And I think that's just such an interesting question because finally someone is looking at the perspective as climate change knows no boundaries, but the countries themselves are different as much as every individual is different. So I think broadly, just to phrase that question, those countries with limited, let me look at the question again, 1 second. Very remote places and wanting to strengthen climate law and governance would imply that those countries have limited institutional capacity, realistically, to implement ambitious climate laws. And I think in that case, ambition must be matched with capacity, because for many countries, especially in Africa, and perhaps other parts of the global south, the most effective way or effective pathway then would be a phased approach, and perhaps starting with clear mandates, allocating responsibilities across ministries, building strong monitoring, reporting, and verification systems, targeting capacity building, including and especially judicial training, everything we alluded to earlier, can dramatically scale implementation. And ambition should grow with capacity, but the absence of capacity should never be treated as a barrier to beginning. And then just to end on that question, I'd like to just make it particular to Africa. And climate laws in Africa succeed when they are designed as developmental laws. So not just looking at environmental statutes, but this would actually mean embedding climate objectives into sectors that drive development on the ground. This would look like energy access, food security, transport, housing, mining, land use. So this would mean including provisions on just transition, social protection, and public participation. Because African experience shows us that when climate governance aligns with jobs, equity, and livelihoods, then and only then does implementation become more durable and more politically supported. Thank you very much.
Thank you, Zenaida. Does anyone wants to do another final remark here? Nick, Professor Zima, Carter, calling by name. Well, so I'm gonna make mine, and after that we can close, right, Professor Marie? And so this was a great experience, I believe, for everybody. And coming from, being here in Brazil, it's very nice to hear from, people from all over the world about the difficulties that, their countries are facing, and the reflections about it. And I think that in terms of governance and public policies, I believe that we kind of have mostly, regarding the theme, there's some type of, similarity in terms of the problems we're facing. And specifically in relation to poverty, and here in Brazil, it's very hard to talk about energy transition and net zero when we have people that don't have what to eat, they don't have access to electricity. So this is just like Zenaida was mentioning, this is something that should walk together with, the policies and the NDCs and the goals to achieve the climate, this climate goals we have in the net zero. So thanks so much for your presence here. I think we're getting to the end, right? And thank you so much, Railla, for the partnership here, Professor Marie, Joe, and everybody. So I think